Welcome to the World of Trade podcast, where we explore the latest developments on the global trade stage. Today, May 30, 2025, we will explore the latest developments regarding the tariffs imposed by former President Donald Trump. The legal foundations of Trump's tariffs were anchored in statutes that many constitutional scholars would later argue were stretched beyond their original intent. When the tariffs were first announced, the administration leaned heavily on the authority of the Trade Expansion Act of 1962, which provided the president with the power to adjust imports if it was determined that national security was at risk. Specifically, Section 232 of the Act allowed the president to impose trade restrictions when imports were found to threaten national security. This was coupled with the invocation of the International Emergency Economic Powers Act, IEPA, of 1977, a statute intended to grant the president broad authority to regulate commerce during a declared national emergency. Trump's argument was that the influx of foreign steel and aluminum posed such a threat, undermining the domestic production base vital for defense. In theory, this seemed to align with the statutory language, but in practice, critics contended that the interpretation was a significant overreach. After all, the U.S. was not facing an immediate crisis in its defense supply chain, and many viewed the national security rationale as a convenient pretext for protectionist economic policy. As these arguments played out in public discourse, legal experts and trade analysts began to question the sustainability of the administration's strategy. The tariffs quickly expanded beyond their initial targets. Soon, additional rounds of tariffs were imposed on a broader range of goods from China and other trading partners. Trump's team insisted that these measures were necessary to counter what they described as unfair trade practices and intellectual property theft. But the broader use of tariffs based on national security grounds fueled accusations that the administration was circumventing the Constitution's provisions granting Congress the power to regulate commerce. Article 1, Section 8 of the U.S. Constitution states unequivocally that the power to lay and collect taxes, duties, imposts, and excises resides with Congress. For many observers, the president's unilateral actions represented an erosion of the checks and balances designed to prevent exactly this kind of power consolidation. Meanwhile, businesses and industry groups began to mobilize against the tariffs. Organizations such as the National Foreign Trade Council and the U.S. Chamber of Commerce voiced their concerns, arguing that the tariffs were damaging American companies far more than they were helping. Many of these groups lobbied Congress to intervene or at least clarify the limits of executive authority in trade policy. Some lawmakers, including both Republicans and Democrats, expressed unease about the breadth of the administration's interpretation of the statutes. At the same time, legal challenges started to take shape. Plaintiffs in these cases often included importers, trade groups, and industry associations, many of which had been hit hard by the sudden cost increases caused by the tariffs. Their lawsuits questioned not only the justification for the tariffs, but also the procedural steps taken in implementing them. Critics argued that the administration had failed to provide sufficient evidence of a genuine national security threat, and that the process lacked transparency and public input. It became increasingly clear that the tariffs' legal underpinnings were shaky. While the president certainly had some statutory authority to regulate trade, the use of that power in this case was being interpreted in a way that many viewed as incompatible with both the Constitution and the intent of the original laws. The administration, however, remained defiant, with officials asserting that the president's discretion in national security matters was virtually absolute. This hardline stance set the stage for what would become a protracted legal battle, pitting executive power against the foundational principles of legislative oversight and constitutional balance. As this legal contest began to unfold, attention turned to the courts. Would the judiciary uphold the administration's expansive interpretation of its powers, or would it rein in what many perceived as an overreach? The stakes were high. And the outcome would not only determine the fate of Trump's tariffs, but also clarify the boundaries of presidential authority in trade policy for future administrations. The next chapter in this unfolding story would take us into the courtroom, where judges would weigh the evidence and arguments that had begun to swirl around one of the most controversial trade policy decisions in modern U.S. history. The judicial response to Trump's tariff strategy began slowly but steadily, with plaintiffs initiating lawsuits in district courts across the country. Their arguments centered on two main points. First, that the administration had overstepped its legal bounds by using national security as a catch-all justification, and second, that the process lacked transparency and failed to follow administrative law procedures. One of the earliest and most influential cases emerged in the Court of International Trade, CIT, where a coalition of steel importers filed suit challenging the tariff's legal basis under Section 232 of the Trade Expansion Act of 1962. At first, the administration appeared confident in its legal footing. After all, Section 232 provided broad language that allowed the president to take necessary action if an investigation found that imports were threatening national security. The Department of Commerce had conducted such an investigation and concluded that steel and aluminum imports did pose such a threat. This finding, submitted to the president, became the linchpin of the administration's legal argument. Yet, as the litigation unfolded, it became apparent that the court was not merely rubber-stamping executive claims. Judges on the CIT examined the procedural steps taken by the administration with a critical eye. They looked at whether deadlines had been observed, whether the report's findings genuinely aligned with the administration's tariffs, and whether deviations from the statute's timeline and process invalidated the executive action. In one key instance, the court scrutinized the president's extension of tariffs to additional products well after the statutory 90-day window had closed. This raised fundamental questions about whether the administration could revise or expand tariffs at will, or whether it was bound by the limits of the statute. Moreover, opponents of the tariffs highlighted the lack of public notice and comment in the Commerce Department's investigation. Under the Administrative Procedure Act, major federal regulatory changes typically require agencies to solicit public input before implementing policies. By bypassing this requirement, the administration invited allegations that it had acted in an arbitrary and capricious manner, grounds that courts often use to strike down executive actions. In response, government attorneys argued that national security considerations allowed the president significant discretion and exempted these actions from conventional administrative procedures. They pointed to the language of Section 232, which granted the president authority to act if he deemed it necessary, without requiring him to engage in detailed rulemaking or public debate. However, this interpretation was not universally accepted by the judiciary. As the cases moved forward, some courts began to push back. In a notable ruling, a CIT judge found that the administration had exceeded its authority by expanding tariffs beyond what the Commerce Department had originally investigated. This ruling did not overturn the entire tariff regime, but it signaled a judicial willingness to scrutinize the executive's justifications more closely. It also opened the door for more expansive legal challenges, particularly those that questioned whether the entire national security rationale was being misused as a political tool. Meanwhile, the plaintiffs broadened their legal assault. They began to argue that Section 232 itself was unconstitutional because it effectively gave the president legislative powers that belonged to Congress. This line of reasoning touched on the non-delegation doctrine, a seldom invoked constitutional principle that prevents Congress from transferring its core responsibilities to the executive branch without clear guidelines. While courts have historically been reluctant to enforce the non-delegation doctrine, the argument gained traction in legal circles, especially among conservative scholars who were uncomfortable with the idea of an all-powerful presidency. These broader constitutional claims added new complexity to the legal debate. If successful, they could undermine not only Trump's tariffs, but also the legal architecture that future presidents might rely on for emergency economic actions. Yet courts remained cautious. They understood the implications of striking down a statute that had been in place for decades, especially one tied to national security. Still, by allowing these challenges to proceed and by issuing narrow rulings against specific executive actions, the judiciary began to signal that it would not uncritically accept the administration's expansive interpretation. The political environment added further tension. Some lawmakers, concerned about losing their constitutional role in setting trade policy, began to file amicus briefs in support of the legal challenges. Senators from both parties, some motivated by ideological concerns, others by economic harm to their constituents, joined the growing chorus calling for judicial intervention. Their arguments emphasized the importance of reasserting congressional authority over trade and limiting the president's ability to act unilaterally under vague statutory mandates. As the legal battle intensified, the implications stretched beyond the courtroom. Businesses began adjusting their operations based on the outcome of each ruling. Some firms suspended investment plans, while others scrambled to restructure supply chains to avoid punitive tariffs. International trading partners, particularly the European Union and China, watched the litigation closely, understanding that a favorable ruling for the plaintiffs could dismantle large portions of Trump's tariff regime and reopen markets. By late 2020, the stage was set for a pivotal moment in the fight. Although the district courts had begun to question aspects of the administration's actions, the government continued to defend its approach with vigor. The Department of Justice sought stays of rulings unfavorable to the executive branch, buying time as it prepared to appeal decisions that threatened the president's authority. This led to a broader discussion in the legal community about the role of the courts in policing executive overreach, particularly in areas involving international trade and national security. At the heart of the judicial resistance was a concern about setting dangerous precedents. If the courts allowed this interpretation of Section 232 to stand unchallenged, future administrations might use the statute to justify virtually any economic action under the guise of national security. That potential slippery slope weighed heavily on judges grappling with the complex intersection of constitutional law, statutory interpretation, and executive power. The coming months would see these disputes escalate to the appellate level, where panels of federal judges would be forced to consider not just the legality of specific tariffs, but the constitutional architecture of American trade policy. A temporary legal reprieve was on the horizon, but so was a reckoning, one that could fundamentally redefine the boundaries of presidential power in matters of economic governance. The turning point in the legal saga came with the appeals court's decision to grant a temporary stay on a lower court ruling that had declared aspects of the tariff expansions unlawful. This stay did not mean the court sided entirely with the administration, but it did allow the tariffs to remain in effect while the case moved through further legal review. For businesses and policymakers alike, this was both a reprieve and a reminder of the ongoing uncertainty surrounding America's trade policy under the Trump administration. The stay came from the U.S. Court of Appeals for the Federal Circuit, the specialized court that hears appeals from the Court of International Trade. The court emphasized that granting the stay did not represent a final ruling on the merits, but was rather a procedural move to maintain the status quo. Still, this decision had major consequences. By preventing the lower court's ruling from immediately dismantling parts of the tariff regime, it effectively extended the life of Trump's trade strategy, at least temporarily. The appellate court's rationale leaned heavily on the principle of judicial prudence. The judges noted that unraveling tariffs already in place could cause economic disruption, especially if a higher court later reversed the lower court's decision. They also acknowledged the significance of the constitutional questions at stake, suggesting that such matters demanded a cautious and comprehensive legal review. The stakes were no longer just about steel or aluminum. The issue had ballooned into a referendum on presidential authority in economic policymaking. This legal breathing room was a gift to the administration, which used it to reassert its narrative that the tariffs were not only lawful, but necessary for national resilience. Officials from the Department of Commerce and the Office of the U.N.S.A. Trade representative took to the media circuit, presenting the court's stay as a validation of their actions. They reiterated the argument that America had long suffered from unfair trade practices, especially from China, and that decisive executive action was required to level the playing field. Internally, however, the administration was aware that the stay was only a temporary victory. Legal advisors recognized that the appellate judge's language was non-committal and even hinted at discomfort with the administration's expansive interpretation of the law. The White House quietly began considering contingency plans in case the courts ultimately ruled against them. These included pivoting to other legal frameworks, such as Section 301 of the Trade Act of 1974, which allows for retaliatory tariffs in response to unfair foreign trade practices, but comes with its own legal complexities. Meanwhile, businesses remained caught in a holding pattern. The uncertainty created by the litigation and the stay made long-term planning nearly impossible for many companies. Manufacturers and importers couldn't be sure whether the next court ruling would lift the tariffs or leave them intact. Some firms began hoarding inventory, anticipating possible changes in duty rates. Others negotiated temporary pricing arrangements with suppliers, hedging against legal outcomes that could dramatically alter their cost structures. Internationally, the response was mixed. Some trading partners expressed frustration that the United States was dragging its feet on resolving what they saw as illegal trade barriers. Others interpreted the stay as a signal that courts were reluctant to interfere with presidential authority, at least in the short term. European Union officials, for example, held off on retaliatory measures while waiting to see how the legal process would unfold. China, by contrast, continued its own tariffs on American goods, unwilling to rely on American courts to shape its strategy. The legal community, too, was abuzz with analysis. Law schools, think tanks, and legal journals began churning out essays dissecting the implications of the temporary stay. Some commentators praised the court's caution, arguing that a rushed decision could destabilize global markets. Others criticized the move as judicial abdication, asserting that the courts had a duty to halt unlawful executive action immediately, even at the risk of economic dislocation. The stay also revived interest in the broader non-delegation debate.